In today's video, we're continuing on with our series on battery and aggravated battery crimes in Florida. And in this particular one, we're going to talk about what happens after someone is arrested for that crime of any type of battery-related crime. I'm Adam Rossen, criminal and DUI defense lawyer in South Florida, owner and founder of the Rossen Law Firm. So let's talk a little bit about what happens after you get arrested for any type of battery crime. So once you get arrested for battery, most likely they're going to take you to their local jail and they're going to question you. They're either going to question you at the jail, or sometimes they'll even just question you on scene. But whenever they're done with that initial phase, then they're going to take you to the county jail to be booked and processed. If this is in Broward County, you're going to go to BSO's main jail, which is in downtown Fort Lauderdale. If you get arrested in anywhere in Palm Beach County, you're going to go to Gun Club, which is the sheriff's office facility on Gun Club Road. It's called Gun Club. And you're either going to get a standard bond, which means you'll be able to post bond right away, or you'll have to wait for magistrate court or first appearance court. Now, first appearance court is done every single day of the year, Christmas, New Year's. I've been to court on pretty much every holiday you can imagine for clients. And at that first appearance, that court, what's going to happen is there's going to be a prosecutor there, there's going to be a judge there, and if you don't have an attorney, you can have an attorney there with you right away, and we're going to be arguing for conditions of release. Okay, they could be monetary, meaning money, or bond, right? So it could be $1,000 bond, $5,000 bond, $20,000, $30,000, $40,000 bond, depending on how serious the battery crime is. And so that's usually one of the stipulations. If there is a monetary bond, then you can either pay the full amount of money. So let's just say it's a $10,000 bond. You can pay the full amount, $10,000, and tie that money up until the end, assuming you go to court. You make all your court appearances, and when the case is over, you get the money back. Or if you don't have that money, you can always hire a bail bondsman. You pay them 10%. Sometimes they require collateral, sometimes they don't. It depends on a variety of factors. And so in this particular example, you'd pay them $1,000, and then the bondsman would get you out. Now, you would not be entitled to that money back. That would be the bondsman's fee. So that's monetary bond. There's also other conditions of bond. They can have in Palm Beach what they call OR or SOR, which SOR stands for supervised release, basically, supervised on recognizance. Or in Broward, they call it pretrial release. And those are forms of being on probation while the case is still pending. And there's pros and cons to that. So a con is we usually don't want our clients to be monitored if they don't have to be, because any little mistake, any little misstep or issue or problem, and you can have a warrant out for your arrest for violating those terms and conditions. But on the other hand, if bond is going to be very expensive, let's say $30,000, $40,000, $50,000, and we can convince a judge to give you maybe a $5,000 bond and some form of supervised release, for those clients, that most likely is more attractive to them because it's less money and it'll actually get them out of jail, as opposed to wasting or tying up $50,000, with a significant bond. So those are some things, certain bond conditions that will be discussed at first appearance. Also, on any battery crime, there's going to be no contact with the victim. If the victim wishes contact, the victim is allowed to show up at that first appearance court. Oftentimes we've had the victim there arguing for contact, whether it's full contact or even just telephone or third-party contact. But without that happening, 99 out of 100 times the judge is going to grant no contact with the alleged victim. And when the judge is determining, what kind of bond conditions to set, he or she, they're looking at your criminal history. So they're looking at prior crimes. They're looking at ties to the community, meaning, are you going to show up to court? Do you have a reason to flee, to just go to another country or just go back to another state, and will you not show up because you don't have any ties to South Florida? Obviously, the more ties that you have, the better or lack of criminal history that you have, usually that means lower bond, lower restrictions, which is better for the client. Another thing that the court's going to look at is the severity of the crime, right? Is this a misdemeanor? Is this a felony? Is there a mandatory minimum prison sentence involved, which on some of these cases there can be? Was a firearm used? So basically, how serious is the case, and how much evidence is alleged in the initial police reports to against you? So these are all the factors that the court, that the judge in the court and the prosecutors and your defense attorney are going to be arguing over in order to try to set reasonable conditions of bond. The court can also order drug and alcohol testing on supervised release or pretrial release if the reports say that drugs or alcohol were involved. So there's a lot of power that the judge has at this first appearance court to really shape conditions of release. So what happens when you post bond or you get out of jail? So in Palm Beach, you usually leave jail with a court date for about 30 days or so out. All right. Now in Broward, you don't get a court date when you leave jail. It doesn't mean that there's not going to be court. They send you one in the mail. And once you get out of jail after you've been arrested, there's a 30 to 40 day filing window. And this 30 to 40 days can be the most essential part of any case. So I wanted to explain what that is. So when you've been arrested, right? You've been arrested for a crime. You've been accused of a crime, but you haven't been formally charged yet. The prosecutor's office, the state attorney's office, they have not formally filed charges and decided what they're going to try to prosecute you for. So they take that first 30 to 40 days, and that's when they're examining the evidence, they're reviewing everything, and they're trying to decide what they're going to do. We've found that this initial, what we call the pre-filing stage, is the most essential part of any criminal case. We've had cases that clients were arrested for attempted murder, extremely serious cases. And when you hire an attorney right away and we're able to get involved and negotiate and talk with the state attorney's office, sometimes we get them reduced to lesser felonies. Sometimes we've even gotten them reduced to misdemeanors. And on a few occasions, we get the whole case completely gone right away because we have evidence. We send our investigators out, we get witness statements, pictures, video, whatever, and we find out that the police did an improper or a very lackluster investigation, and we can provide this information to the prosecutor's office really immediately within this first 30 to 40 day time frame. So this time frame is essential. If the prosecutors do file charges, well, then you will have court dates. And if you don't have an attorney, you'll need to be there for every single one. And if you're not, you're going to have an arrest warrant. And if you do have an attorney, most attorneys will have you file or sign what's called a waiver of appearance. We do that on every single one of our cases. And it just basically means you don't have to show up for an arraignment or for status checks or little court dates that are really not important. And we do that for all of our clients' convenience, so they can go back to work and do what they do without having to really inconvenience themselves for minor court dates. And so that's the overall process of what happens after you get arrested for any type of battery, aggravated battery, felony battery, all the different battery crimes in Florida. Hopefully that helped. If you have any questions for us, just give us a call, 754-206-6200. We do free strategy sessions, and we'd love to help you out.